Necessary party. A necessary party is one who is not indispensable, but who ought to be joined as a party if complete relief is to be accorded as to those already parties, or for a complete determination or settlement of the claim, subject of the action. Whenever in any pleading in which a claim is asserted, a necessary party is not joined, the pleader shall set forth his name, if known, and shall state why he is omitted. Should the court find the reason for the omission unmeritorious, it may order the inclusion of the omitted necessary party, if jurisdiction over his person may be obtained. The failure to comply with the order for his inclusion without justifiable cause shall be deemed a waiver of the claim against such party. Let's discuss the case of Seno versus Mangubat, GR number L-44339, December 2, 1987. So, in this case, Seno mortgaged a parcel of land in favor of Mangubat. On the assurance of Mangubat that he will respect the agreement on the mortgage, Seno executed a deed of absolute sale over the property in favor of Mangubat and two other vendees. Mangubat was able to obtain title in his name on the other alleged vendees. The two other vendees later executed a deed of absolute sale, transferring their share to Mangubat. Mangubat was able to obtain title over the property in his name by virtue of the latter's sale. Mangubat sold the property in favor of spouses Francisco Lozame and Virgita Peñaflor. The spouses filed an ejectment case against Seno. Seno now filed an action for reformation of deed of sale executed in favor of Mangubat and annulment of the subsequent sale to said spouses. On motion of defendant spouses Luzame and Peñaflor, the trial court ordered the inclusion as defendants of Andres Evangelista and Bienvenido Mangubat, or the two other vendees, on the ground that they are indispensable parties. Plaintiffs filed their amended complaint in compliance with the court's order, impleading Andres Evangelista and Bienvenido Mangubat as defendants. The issue in this case is whether the other two vendees were indispensable parties. The Supreme Court explained that indispensable parties are those with such an interest in the controversy that a final decree would necessarily affect their rights, so that the courts cannot proceed without their presence. Necessary parties are those whose presence is necessary to adjudicate the whole controversy, but whose interests are so far separable that a final decree can be made in their absence without affecting them. In the present case, there are no rights of the other two vendees to be safeguarded if the sale should be held to be in fact an absolute sale, nor if the sale is held to be an equitable mortgage. Defendant Marcos Mangubat became the absolute owner of the subject property by virtue of the sale to him of the shares of the aforementioned defendants in the property. Said defendants or the two other vendees no longer have any interest in the subject property. However, being parties to the instrument sought to be reformed, their presence is necessary in order to settle all the possible issues of the controversy. Whether the disputed sale be declared an absolute sale or an equitable mortgage, the rights of all the defendants will have been amply protected. Defendants' spouses Luzame, in any event, may enforce their rights against defendant Marcos Mangubat. In fact, the plaintiffs were not after defendants Andres Evangelista and Bienvenido Mangubat, or the two other vendees, as shown by their non-inclusion in the complaint and their opposition to the motion to include said defendants in the complaint as indispensable parties. It was only because they were ordered by the court a quo that they include the said defendants in the complaint. The lower court, therefore, erroneously held that the two other vendees are indispensable parties. Next case, Spouses Aboitiz versus Spouses Po, GR numbers 28450 and 28497, June 5, 2017. Okay. Spouses Aboitiz filed a petition. Spouses Po also filed a petition. These cases were consolidated. The case involves a parcel of land in Mandaue City. This parcel of land originally belonged to the late Mariano Seno, or Mariano. Mariano executed a deed of absolute sale in favor of his son, Ciriaco Seno. This property included 2 lots. Okay? Ciriaco sold the 2 lots to Victoria Po. The parties executed a deed of absolute sale. Mariano died and was survived by his 5 children, Esperanza, Ramon, Benita, Simeon, and Ciriaco. In 1990, Peter Po discovered that Ciriaco had executed a quitclaim dated August 7, 1989, renouncing his interest over lot number 2807 in favor of petitioner Roberto. In the quitclaim, Ciriaco stated that he was the declared owner of the said lots. So the spouses Po confronted Ciriaco. By way of remedy, Ciriaco and the spouses Po executed a memorandum of agreement in which Ciriaco agreed to pay Peter the difference between the amount paid by the spouses Po in consideration or as consideration for the entire property and the value of the land the spouses Po were left with after the quitclaim. However, lot number 2835 was also sold to Roberto. The Mariano heirs, including Ciriaco, executed separate deeds of absolute sale in favor of Roberto. Thereafter, Roberto immediately developed the lot as part of subdivision called Northtown Homes. Okay, in 1991, the spouses Po declared the lot for taxation purposes and was issued tax declaration. Roberto Aboitiz also declared the lot for taxation purposes and was also issued a tax declaration. With an annotation, this tax declaration is also declared in the name of Mrs. Victoria Po, married to Peter Po. Later, Roberto Aboitiz filed an application for original registration of lot number 2835 with the Mandaue City Regional Trial Court acting as land registration court. In its decision, the trial court granted the issuance of original certificate of title in the name of Roberto Aboitiz. The lot was immediately subdivided with portions sold to Ernesto and Jose. Now the issue in this case is whether the Mariano heirs are indispensable parties. The spouses Aboitiz argue that the Mariano heirs are indispensable parties who should have been impleaded in this case. The Supreme Court held that the property owners against whom the action for reconveyance is filed are indispensable parties. No relief can be had, and the court cannot render a valid judgment without them. The property has been sold to respondents Jose, Ernesto, and Isabel. Thus, they are indispensable parties. The Mariano heirs, as the alleged sellers of the property, are not indispensable parties. They are at best necessary parties. Necessary parties may be joined in the case to adjudicate the whole controversy, but the case may go on without them because a judgment may be rendered without any effect on their rights and interests. It is clear that the Mariano heirs are not indispensable parties. They have already sold all their interests in the property to the spouses Aboitiz. They will no longer be affected, benefited, or injured by any ruling of the court on the matter, whether it grants or denies the complaint for reconveyance. Next case, Kabutihan versus Land Center Construction and Development Corporation, GR number 146594, June 10, 2002. The facts in this case. Respondent engaged the petitioner as a facilitator to recover a certain property. Petitioner filed an action for specific performance with damages, praying the respondent be ordered to execute the appropriate document assigning, conveying, transferring, and delivering the particular lots in her favor as compensation for the undertakings she performed and accomplished. Respondent sought the dismissal of the complaint on the ground, among others, that Winifredo Foro, Nicanor Ladan Sr. and Attorney Prospero Anave are not named as plaintiffs in the complaint. Petitioner is not named as representative of Foro, Radan, and Anave by virtue of a special power of attorney or other formal written authority. According to the rules, where the action is allowed to be prosecuted or defended by a representative or someone acting in a fiduciary capacity, the beneficiary shall be included in the title of the case and shall be deemed to be the real party in interest. The RTC ruled that the action was filed only by petitioner. There was no allegation that she had been authorized by Foro, Radan, and Anave to represent their respective shares in the compensation. Now, the issue: whether the dismissal of the complaint on the ground of non-joinder of necessary parties was correct. Petitioner claims that she was duly authorized and empowered to represent the members of her group and to prosecute their claims on their behalf via a special power of attorney executed by Foro, Radan, and Anave. Besides, she argues that the omission of her companions as plaintiffs did not prevent the RTC from proceeding with the action because whatever judgment would be rendered would be without prejudice to their rights. In the alternative, she avers that the trial court may add or drop a party or parties at any stage of the action and on such terms as are just. The RTC ruled that there was no allegation anywhere in the records that petitioner had been authorized to represent Foro, Radan, and Anave, who were the real parties in interest with respect to their respective shares of the 36.5% claim. So such being the case, the RTC held that the trial court never acquired jurisdiction over the subject matter of their claims. Is this correct? The Supreme Court held that neither a misjoinder nor a non-joinder of parties is a ground for the dismissal of an action. Parties may be dropped or added by order of the court on motion of any party or on the court's own initiative at any stage of the action. The RTC should have ordered the joinder of such party, and non-compliance with the said order would have been ground for dismissal of the action. Although the complaint prayed for the conveyance of the whole 36.5% claim without impleading in the companions of petitioner as party litigants, the RTC could have separately proceeded with the case as far as her 20% share in the claim was concerned, independent of the other 16.5%. This fact means that her companions are not indispensable parties without whom no final determination can be had. At best, they are mere necessary parties who ought to be impleaded for a complete determination or settlement of the claim subject of the action. The non-inclusion of a necessary party does not prevent the court from proceeding with the action, and the judgment rendered therein shall be without prejudice to the rights of such party. Next case, Catadrilla v. Lauron, GR number 179011, April 15, 2013. The facts in this case: petitioner filed a complaint for ejectment against respondents. Petitioner is one of the co-owners of the subject lot. On petition for review, the Court of Appeals found that only petitioner filed a case for ejectment against respondents and ruled that the other heirs should have been impleaded as plaintiffs, citing Section 1 Rule 7 and Section 7 Rule 3 of the Rules of Court, that the presence of indispensable parties is a condition sine qua non. The issue in this case is whether the petitioner's co-heirs should have been pleaded as co-plaintiffs in the ejectment case against respondents. The Supreme Court held that petitioner can file the action for ejectment without impleading his co-owners. In We versus De Castro, wherein petitioner therein argued that the respondent cannot maintain an action for ejectment against him without joining all his co-owners, the Supreme Court ruled in this wise. Article 487 of the new Civil Code is explicit on this point. This article covers all kinds of action for the recovery of possession, that is, forcible entry on unlawful detainer, or acción interdictal, recovery of possession, or acción publiciana, and recovery of ownership, or acción de reivindicación. As explained by the renowned civilist Professor Arturo Tolentino, a co-owner may bring such an action without the necessity of joining all the other co-owners as co-plaintiffs because the suit is deemed to be instituted for the benefit of all. If the action is for the benefit of the plaintiff alone, such that he claims possession for himself and not for the co-ownership, the action then will not prosper. The Supreme Court cited the case of Carandang versus heirs of de Guzman, where the court declared that a co-owner is not even a necessary party to an action for ejectment, for complete relief can be afforded even in his absence. The court held that in suits to recover properties, all co-owners are real parties in interest. However, pursuant to Article 487 of the Civil Code and the relevant jurisprudence, any of them may bring an action, any kind of action for the recovery of co-owned properties. Therefore, only one of the co-owners, namely the co-owner who filed the suit for the recovery of the co-owned property, is an indispensable party thereto. The other co-owners are not indispensable parties. They are not even necessary parties, for a complete relief again can be afforded in the suit even without their participation, since the suit is presumed to have been filed for the benefit of all co-owners. What happens when a necessary party is not joined in the action? When an indispensable party is not before the court, the action may be dismissed. The absence of an indispensable party renders all subsequent actuations of the court void for want of authority to act, not only as to the absent parties, but even as to those present. On the other hand, the non-joinder of necessary parties did not result in the dismissal of the case. Instead, Section 9, Rule 3 of the Rules of Court provides for the consequences of such joinder. Okay? Whenever in any pleading in which a claim is asserted and necessary party is not joined, the pleader shall set forth his name if known, and shall state why he is omitted. Should the court find the reason for the omission unmeritorious, it may order the inclusion of the omitted necessary party if jurisdiction over his person may be obtained. The failure to comply with the order for his inclusion without justifiable clause shall be deemed a waiver of the claim against such party. Okay, so is that clear? The non-inclusion of a necessary party does not prevent the court from proceeding in the action, and the judgment rendered therein shall be without prejudice to the rights of such necessary party. Non-compliance with the order for the inclusion of a necessary party would not warrant the dismissal of the complaint. So you remember, when an indispensable party is not impleaded, the court may order that the indispensable party be impleaded, and non-compliance of that order would be a cause or a ground for the dismissal of the action under Rule 17. However, if the order is for the inclusion of a necessary party, non-compliance of the order for the inclusion of a necessary party would not warrant the dismissal of the complaint. This is an exception to Section 3, Rule 17, which allows the dismissal of the complaint for failure to comply with an order of the court, as Section 9, Rule 3 specifically provides for the effect of such non-inclusion. It shall not prevent the court from proceeding in the action, and the judgment rendered therein shall be without prejudice to the rights of such necessary party. Section 11, Rule 3 likewise provides that the non-joinder of parties is not a ground for the dismissal of the action. Here is a clear illustration. Okay, the non-joinder of the necessary party. In this case, the pleader shall set forth his name if known and shall state why he is omitted. Should the court find the reason for the omission unmeritorious, it may order the inclusion of the omitted necessary party if jurisdiction over his person may be obtained. The failure to comply with the order for his inclusion without justifiable cause shall be deemed a waiver of the claim against such necessary party. It is not a ground for the dismissal of the action, not even under Rule 17 for failure to comply with the order of the court.